Good morning, everybody. How are you? Happy New Year. Oh, it's so enthusiastic.
Happy New
Year.
That was so was it? Come on. So two things. I had received a number of gifts, and I thank everybody, but there are two gifts that weren't, there's nobody's, maybe they were given without intentionally, without telling me who you were. But this bag, it says to Richard. So I want to know who you are, because I don't want it to go unnoticed. And then if you claim it, whoever the first person claim is the claims it, thank you very much. And then this bag, right? Also, it wasn't you, Cameron?
No, you already know it's
I know what you brought me. Cameron gave me candy. That was very nice, Cameron. That was really nice. Okay, so today
I haven't tasted sugar in 17 years.
And I can tell you this, I didn't taste his sugar either. So it's continuing. It's just continuing right along. All right, so today we're going to welcome Sarah Menchaca with Southern California Funding. Sarah, if you would like to take over, please.
Hi there, Rich. Good morning, everyone. Happy New Year. I'm just here to give a quick rate update. As everyone knows or should know by now, the conforming loan limits have increased. So for Orange County, 766,550 is the new conforming loan limit. So anything priced out today, assuming a 75% loan to value, 760 credit score, primary residence in a single family home, the range is between 5.999% to 6.375% with 0 to 1 points being charged. High balance, so that's a loan limit up to 1,149,825. The range is between 6.375 to 6.625. And a jumbo loan, we're looking at 6.5 to 6.875. I do also want to just let everyone know that we are doing HELOCs, which are home equity loans of credit. News came out that revolving credit is the highest that it's been since March of 2022. So you might have some clients out there that need some help with some debt consolidation. So just keep that in mind that we do offer HELOCs as well.
That didn't work out very well. Okay, I hope you didn't hear that. Sorry, I dropped one of the speakers.
Oh, no.
Okay, good. Any questions for Sarah? Yeah, so every single year, California passes new laws, and we're going to go over those that I think are applicable to us. As a matter of fact, there's so many changes in the laws that I don't think are necessarily going to affect us, at least in the real estate industry. So there's a lot to actually talk about, and some of the things aren't necessarily something you're going to run into every day, but I thought I would keep it in anyways, because if you have questions from clients, you should be able to answer that. So previously, with commercial financing, an APR was not required when disclosing terms of financing. Then SB 33 came into effect. And now for commercial financing, an APR must be disclosed with every single commercial loan, something that was not applicable and was going to sunset. And then we're going to be seeing at some point in time changes to the Homeowner's Guide to Environmental Hazards booklet. Now it's interesting, the Senate bill was passed, or Assembly bill was passed, but there's no money to update it. So it's anticipated that private resources will come into play to update the environmental hazards booklet. And it's probably going to be coming out of all of us, as a matter of fact. So not a dramatic change, but it's going to talk about climate change, things like that. So additional things that nobody ever seems to read. Now, this one's really critical. Flippers of residential 1 to 4 properties must disclose recent repairs and renovations to the property in addition to all other existing disclosures. Applies to properties that are resold within 18 months of closing. So standard TDS categories, exemptions, and cancellation rights apply. And I'll go over the TDS aspects of it. So this applies now if it's a residential property of 1 to 4 units. The seller accepts an offer within 18 months of acquiring the property. And then renovations or repairs were performed by a contractor. And it's likely, if it's a flip, that most likely a contractor was involved. So additional disclosures, room additions, structural modifications, other alterations, so that's all encompassing, I would say, repairs, a copy of any permits if obtained. So that's a big deviation from what we've had to provide in the past. Or if the seller contracted through a third party was not provided with a copy of the permits, the seller can inform the buyer that they can contact the contractor directly. And the contractor can give those disclosures themselves. So now the threshold, if the cost of labor and materials was greater than $500, the seller will disclose the name of each contractor on the job. That's a big deviation from anything we've had to do so far. And the contact information for each contractor that was on the job. It begins July 1st. And the disclosure comes within the transfer disclosure statement law. So it applies in the same circumstances as the TDS does. And what does that mean? For the most part, there are very few properties or sales that are exempt from the TDS disclosure law. So what's critical about providing somebody with a TDS if there's no exemption? Remember, if you don't provide a TDS, you're required to. The buyer has a right of rescission through the time that you actually provide that TDS. So now the same guidelines apply to this disclosure. If you're in a transaction and you don't provide this necessary disclosure, even if the buyer removes all contingencies, and then this information is provided, they're going to have a 3 to 5 day right of rescission. So you can see just how critical this is in regards to providing that information. So it has the same exemptions as the transfer disclosure statement law. I see questions back there. Or you're wondering? So what are exemptions from providing the transfer disclosure statement? If it's a property that's bought by an investor and sold by an investor, are they exempt from the TDS law? Correct. Very good. They're not exempt. But let's say, for example, I die and my beneficiaries acquire the property and my beneficiaries did not live in the property during the last year. They're exempt from providing a transfer disclosure statement. So there's very few exemptions, as a matter of fact. So most people are subject to providing a TDS, meaning anyone who's buying and selling a property, you don't have to be called a flipper, but maybe even if you moved into the property, you renovated it with no intention of just flipping it, but something changed in your life, you're subject to the same reporting requirements.
Been 18 months.
18 months. That's so I buy it. And if I accept an offer within 18 months, good morning, Ruth, from the time that I acquired the property.
Now, if there is a failure to disclose like this,
Mhm.
TDS, and parties find out about it after the close of sale, or is the seller going to be open to liability by not providing it?
Absolutely. So what are the damages? That's what you're going to have to prove. Same with the TDS. If you don't provide a TDS, then what is the liability of the seller? Well, it could be related to anything they did not disclose. So that's a good question in regards to what this could consist of, or somebody's thought in terms of the damage. So real life examples we've experienced. Property was modified years and years ago, and there were some structural aspects that were modified. And then the buyer claimed that, oh, I was not made aware of it. And then, of course, they had their contractor come in and say it was going to be $375,000 to correct this area was where a wall was removed. So that litigation went on for years and years, as a matter of fact. So could somebody, I think it's likely if there are substantial renovations to a property, could they make a claim that it wasn't done properly, or if there weren't building permits? Say absolutely. So the biggest risk, well, we want the disclosures to go out. The disclosures go out and it removes the right to rescind from the buyer. That's what's critical. Or they rescind within 3 to 5 days following receipt of those disclosures. We just need to follow the same time frames. But typically we want to give the TDS within the first 7 days. So if we never give the TDS or we never give these disclosures, through the close of escrow, a buyer can cancel upon receiving the disclosure. Or they can just cancel if they never get it before the close of escrow.
With that in mind, would you consider a best practice to recommend to your sellers if they have a TDS from the prior transaction when they purchased the property, that they also provide that with disclosures?
I think it's a good idea. Why not? We have nothing to hide because they're aware of whatever the information is on the TDS or the seller property questionnaire.
Because I can see if you have property for 10 years, something slips your mind when you purchased it that was disclosed to you. And then if somebody comes back to you after the fact because you failed to disclose it on your TDS.
Yeah, I don't disagree, but then the term aware is always used. It's what the seller is aware of. But if it's a material item, there's no time frame in regards to which you should not be disclosing that material item, even though it was corrected. If there is a crack in the slab and you corrected it, should you disclose that? I would say absolutely. Or a slab leak, yeah, I would disclose it. And then I think questions, by the way, we have an attorney from Property ID coming in next Tuesday to talk about the natural hazard disclosure. It's very complicated, and the disclosures that are incumbent upon us to provide are very complicated, and I don't think it's necessarily clear. But the law has changed, and so there are some different aspects now associated with disclosure with the NHD. So now it is going to include, the NHC is going to include high as well as very high hazard severity zones by explicitly highlighting 3 new categories of the FHSZ. So if the property is located in any of these zones, so very high severity zone, then the defensible space for properties built before 2010, which is associated with fire hardening disclosures, would be required. So now we have new categories going to be showing up on the NHD report. The new categories are going to be, so we're going to see a yes or no. Then is it in a high fire hazard severity zone, in a state responsibility area? So remember, we're going to be able to, good morning, we're going to be able to read the NHD report to see that, as a matter of fact, and it's going to guide us in regards to how we're going to assist our clients to complete the FHDS disclosure. Or it could be a very high fire hazard severity zone in a state responsibility area or a local responsibility area. So you can see now it's being further defined. So if in the event we look at the NHD report and any of these 3 boxes are checked, then we should actually look at the FHDS, our disclosure, to assist us, that we should use this information, which will assist us in regards to assisting the seller as to disclosing the hazard zones if they are in those hazard zones. And it could also affect their insurance. So that's very important that we look at the NHD report to have a better understanding of it, since there's going to be more clarity. Also, there's going to be information that's going to be available to us that we can use to discern between high or just severe zones, actually. Or is it a state responsibility area or a local responsibility area? So it's broken down into those categories. And that's why I thought we're better off getting somebody who's an expert in this to address this, because it's a question on virtually every single transaction and what our disclosure requirements are going to be. So next Tuesday, I would encourage everybody to attend. Something else that has come up recently in one of our meetings is in regards to ADUs. So it allows local agencies to adopt ordinances to allow the separate conveyance of an ADU from their primary residence as a condominium. What does that mean? It just means you possibly could sell an ADU separately from the primary residence, but there are requirements that are going to have to be met, and it's pretty complicated. So Assembly Bill 1033 allows local agencies to adopt ordinances to allow the separate conveyance of ADUs and primary residences as condos. I have a property, I've built an ADU, I'm going to have to convert it to a condominium, or both properties. It's going to be a condominium, as a matter of fact, if I want to have the ability to sell that ADU separately or sell the primary residence separately. So now that's going to be coming, it's permissible. It's going to require local authority also. So state government's going to allow it. And I think as we go along in today's discussion, we're going to find out that the state is going to be forcing this on local areas. Huntington Beach, we've heard about Huntington Beach, right? They're very much against growth, and I get that. And they're being sued by the states, by the Attorney General because of that. And I think we're going to see a lot of that, as a matter of fact, if they don't adopt local ordinances allowing a homeowner to add an ADU and then convert it to a condominium, or whatever those two homes are, they'll both be condominiums. But there are requirements.
So just to clarify, if you decide to sell the ADU, you have to convert both properties, both units into condos?
Into a condominium, yes. Subject to the Davis-Sterling Act, exactly.
What's involved with that?
Well, that's a good question. If you think about the CC&Rs that are involved in any type of new developments and the extent of the legal assistance that's required, it's very complicated, I would say. So they're going to have to follow the same guidelines typically as probably any new development would. Now, it may not be to the same extent, but it's going to be a monumental effort, in my opinion, but it's going to be something that's going to become available. And I can see developers actually taking advantage of that also. So here's some of the guidelines. It specifies for this to work that a condominium plan must not be recorded with the county recorder in the county where the real property is located without each lien holder's consent. So if there is a loan on the property, I have a traditional mortgage loan on my main residence, or I get a separate loan for the ADU that I've constructed, it's going to require the consent of each lender that currently holds a security instrument against my property. Then if it's in an existing HOA, it requires the owner of a property that is within an existing homeowners association to receive written authorization of that association before they can record their own condominium plan. And where would we likely see something like that? Good morning, Tommy. Maybe detached condos. There could be sufficient land which would allow someone to build an ADU. Remember, to construct an ADU, it's ministerial, remember, meaning that a local governmental agency cannot impose any additional overlays in regards to constructing an ADU. So state guidelines prevail for the construction of ADU, and each local government can only follow those guidelines. They can't say, well, I want this, this, or this, or this. They're prohibited from doing so. And then in addition to that, so updates the contents of the notice required to be provided by local agencies to any applicant for an ADU, including advising applicants considering selling the ADU as a condominium. Was there a question?
So do you need to sell it as two condos, or can you just sell it as a single family with an ADU?
Absolutely. But the question that came out last year, which is just a week ago, was could I separately sell an ADU, or could I separately sell the primary residence on the property?
Yeah.
So that's why now this is coming into play. So yes, you can just sell it as is with the ADU on it, but you're not going to have separate fee simple interest in those properties.
Yeah, and isn't that simpler?
Of course it is, but with the housing shortage, I think that's what's causing this. Forcing people or giving them the ability to construct these separate individual units so you can sell them individually and not be predicated upon owning both properties, as a matter of fact. So is it more affordable to buy an ADU that's 400 square feet than buying a home that's 1,500 square feet plus a 400 square foot ADU? I think we know the answer to that. So I think that's why this is coming about.
Excuse me.
Yes.
Full-time is attached to the house, like some people, they make their garage as an ADU, so that doesn't apply to those.
It would apply to that also. Yes, it could be an attached condominium, theoretically, if you think about it. If they're able to convert that fee estate from 1 to 2 units, it could be a condominium that's attached.
So since the estate always has a power over
Yes.
the local,
Uh-huh.
how about HOAs? You know, it also has a.
So that's going to be a good question. Will an HOA be prevented from saying, no, we're not going to permit you to do that?
Uh-huh.
And I think that's when these additional laws that are coming into play. Right now, another law that passed before, let's say there's a lawsuit that's filed, and the state or the state attorney general cannot necessarily intervene or also engage in that litigation without going through litigation to get permission. That has changed substantially now. So if there's any perceived violation, the state attorney general, without court permission or without going through litigation, can now enjoin in that existing litigation. And I can see that happening here with regards to what's taking place in the state of California. So if there's an HOA that maybe is deemed to improperly prevent somebody from taking their unit, adding an ADU, and then subdividing and creating a separate HOA, I could see the state attorney general stepping in and suing.
Interesting.
Yes. Yeah. And then also, when you apply for an ADU, now local governments are going to be required to notify you of the different obligations, not obligations, but the ability to take that property, create a condominium, and what it requires to sell those units separately. So that's something else. When you apply for an ADU, they're going to be required to disclose to you. They may not necessarily be obligated to permit it at this point in time, but it seems likely that that's kind of the direction we're going. Everything happens incrementally. And then, oddly enough, then also, if it's established as a condo, then you must notify providers of utilities, water, sewer, and gas of the condominium creation and separate conveyance. Very surprising about that. And then another guideline that was in existence, now that's changing, makes permanent the existing prohibition on local government's ability to require owner occupancy on a parcel containing an accessory dwelling unit. So initially, when constructing an ADU, the owner must have occupied one of the two units. So now that is going to sunset, or that's no longer viable. And an owner of a property does not have to occupy either the ADU or the primary residence. So they can be just simple rentals at that point in time.
So in that case, when it comes to that, what would happen to the loan when it's not assumable?
Well, I would say, and it's going to go back to the origination of that loan. What was the owner's intent when they bought the property? So if their intent was to occupy the unit and a year or two passes, and then they suddenly want to lease the property, I don't see it as being a violation. But if they take out a traditional mortgage loan and that they never had the intent of moving in, and they're just going to construct an ADU and rent out both places, I would say that that probably would be a violation of the lending agreement. The lender could call that due and payable. And then this is just for information only. It may not necessarily affect us, but it gives you some idea of the long arm of the law. So the HCD, the California Department of Housing and Community Development, is now given the ability to, if they find violations within local governments, so on and so forth, they now can report that to the Attorney General to enforce whatever the laws are. So let's go through some of these things. So we know Huntington Beach is against, they're not pro-growth. I get that, right? But now the HCD, they're going to be overseeing these issues. If for some reason a local agency does not provide ministerial approval, for example, on ADU, meaning they're just not following state guidelines or adding their own guidelines or overlays, well, then the HCD is going to probably contact the Attorney General, and then they're going to be sued. Same thing with junior accessory dwelling units. And then also, if there's a prohibition by a local agency from denying a permit for an unpermitted ADU that was constructed before January 1st of 2018, that's very interesting, isn't it? It was built before January 1st, 2018. You now can get a building permit for that ADU. Wow. And if the local government prevents you from doing so, then the HCD is going to report that to the state attorney general's office, and they're going to sue you. And who has unlimited resources? The government, because they take all of your money. And then also, there's different areas that you can construct or subdivide property and build 2 individual units on it. So once again, they're going to be enforcing that if local municipalities attempt to dissuade somebody from doing that or stop that. Then also, to construct 10 units on a parcel or subdivide it is now something that is becoming very simplified. And if the local governments don't comply with that, then the HCD is going to step in and report that to the state attorney general. And then also requires local governments to permit both off-site and on-site improvements to occur concurrently. On-site improvements, framing, things like that. Off-site could be sewer, utilities. And then also affordable housing projects on land owned by religious institutions and nonprofit universities. So it's a very simple process to go through if you're a nonprofit, and I'm not sure exactly what that means necessarily, because they all seem to be for profit, right? Money is always involved. And then protects against demolition and loss of residential units. So what's taking place, the state government does not want older units to be demolished because they believe that's taking away the ability for somebody to have housing. It could be a dump, but it doesn't matter to them. So you can see exactly the long arm of the law in regards to everything we do every single day. And then also, if a local government does not permit you splitting your lot into two, well, also you could be sued ultimately by the state of California, or and this is not going to apply to landlords, it's going to apply to governmental institutions. So just keep that in mind. Any questions about that? And then because we do have clients that reside along the coast, the California Coastal Act previously required their approval for improvements of $25,000 or more. Now that's been increased to $125,000, and it's really not much money, but that does not preclude that homeowner's obligation to obtain local approval. But the Coastal Commission, at least, may be out of the picture if the improvements to protect your property are less than $125,000.
So this is for every area or just?
Yes, for every
coastal?
area in California, correct.
So if I'm improving
Yeah.
my house, it's under 125,000, I don't.
The
need
Coastal
to-
Commission, you're not required to get approval from the Coastal Commission. Yes.
Uh,
So all these homes that are bordering the ocean, and of course, we know it's been taking place recently, you know, with the waves coming in, all these people are trying to protect their property. Well, they're having a very difficult time with the ability to do that. Now, it doesn't mean that, for example, the city of Laguna Beach is going to change their stance in regards to what you can do. But at least the Coastal Commission is not involved, because that could probably add an additional year to the approval process for improvements in some they would like to make.
Right. But
But-
the improvement for other areas require permits.
Oh, it's always going to require a permit from the local agency or the county if it's unincorporated. But at least in this case, maybe the Coastal Commission is not involved. If anyone's building along the coast, it just increases the duration of time for the entire construction process. And then the next one, let's see, limits the ability of developers to sell deed restricted units intended for owner occupancy to purchasers that would rent the unit. So currently we see projects that are constructed that are intended for low income housing.
Mhm.
And then if the developer wasn't able to sell it many times, or even before the ability to sell it, they would petition the local municipality to convert it to rental units. So now that's being prevented also. They can sell it to a nonprofit, but then that's going to be subject to further scrutiny. But they can't just necessarily petition the local agency to convert those from properties that are intended to be sold to rental units. So it tells me that developers really want rental units for these low-income properties. They could probably charge that much more. And then next, housing developments must be approved if consistent with general plan, even if not consistent with local zoning ordinances. It's simplifying the process theoretically in regards to building a property. That's really what it's doing. So municipalities cannot apply their own overlays. And then I included this because it talks about the Attorney General having the unconditional right to intervene in litigation. So if there's litigation, maybe by a developer, or maybe by a nonprofit against a local municipality, now the state attorney general can join in that litigation against that local municipality. And then we touch upon this housing ministerial approval of 10 or fewer units in a development. So once again, no additional overlays can be imposed. So if you have developers who are looking for property, maybe this is beneficial for them. because the ability to construct 10 units on property of 5 acres or less is going to be enhanced. It might be simplified compared to what it has been in the past. Something else we talked about recently was the California Fair Access to Insurance requirements, the FAIR plan. And if you can't get homeowners insurance, you're entitled to seek homeowners insurance through the FAIR plan itself. And it's a conglomeration of insurance companies that provide insurance. So now that's being extended also to commercial properties. And the whole idea of now implementing or including commercial properties is to create or give other insurance companies the ability to provide policies to these property owners that can't get insurance through any other means, excluding through the FAIR plan. So your clients may have questions about that. The next one allows a jurisdiction with local rent control to require an owner of a rent controlled unit to allow a tenant with a permanent physical disability to relocate to an available, comparable, or smaller unit located on an accessible floor of the property and retain their same rental rate. So this is typically, now Santa Ana now has rent control. Los Angeles has rent control. So if there is a disabled individual, they have to meet certain guidelines, and there's a unit on the lower floor that opens, they can actually request and demand that they're entitled to move into that unit at a price no greater than what they're paying currently. Bad, good? That's a good question, right? I don't know. But it's certainly something that is going to be available to them. But I would say when we talk about rent control, now, is this going to be applicable to Santa Ana? I'm not sure, but certainly for Section 8 housing, definitely this is going to be applicable. Anyone that is entitled to Section 8 housing is going to have that right to move or relocate. And it could also be done at the cost or expense of the landlord. So the landlord may have to incur additional costs to accommodate the person who's making that request.
And how much the cost?
It doesn't state, you know, what is going to be a real burden to the landlord.
Yeah, because
That's
sometimes they say give us a 50,000, 100,000 to move out, so,
Yeah, well, that's another issue in regards to somebody that's under rent control.
yeah.
If they, you can't evict them, so the only way to remove them is to entice them with some type of a cash payout. So separate and distinct from this.
What if you want to sell the unit?
I'm sorry, what?
What if you want to sell the unit?
And it's under rent control. You're going to sell it subject to rent control, and the buyer is going to take it subject to rent control. You can only change if it's subject to rent control in Los Angeles. I think it's a pre-1995 property or 94.
I'll say 95.
Single family homes. Then the buyer cannot increase the rent. And the only way they can adjust the rent is if that tenant moves out. And that's what she was getting to. We see a lot of individuals that buy investment property offering a cash incentive to that tenant, saying, hey, if you move out, I'll give you I'll give you $50,000 to move out. As an investment property, what's an investment property worth? Well, it's based upon the rents that you're charging. So maybe it makes sense if I can increase my rents from $1,000 to $3,000 a month, and based upon whatever my cap rate is, I can maybe more than recover the amount of money it costs me to have those people move out.
When did Santa Ana become rent controlled?
September
September 2022.
Oh, was that long ago? 2022? No, I thought it was just, no, 23. Yeah. Yeah.
It's been about 6 months.
Yeah, that's been very long. So rent increases no more than 3% and usually less based upon their formula. Yeah. It's probably not friendly for anybody who's looking to buy investment property. And then there are those landlords that charge screening fees. And before you had to give them evidence of the cost that you incurred by me saying, hi, here it is. You can actually send it via email if both parties agree to that now. If we just simply use rent spray, they're already notified. So they know exactly what the cost is simply for that service. And then the landlord must offer ability to pay in lieu of reliance on credit history and reports in assessing a tenant's rental application when prospective tenant is receiving a government rent subsidy, such as a Section 8 rental voucher. So what is that saying? I'm entitled to a Section 8 assistance and my credit is terrible. So you have to give me the ability to state that if I can't qualify based upon a certain credit score, if I can demonstrate to you that my income is sufficient to service the rent, then you can't deny me housing.
Well,
Yeah.
so credit's no longer a factor because they're gonna say, well, I have a voucher and that's guaranteed, so my income's guaranteed.
And
So
if
you
I
can't deny me
qualify
that.
based upon that income, not because I don't pay any of my bills, but if I qualify based on that income, then you would have to grant me credit, or in a sense, that unit.
So the security deposit can be still used, right? Like if you're not paying the security deposit, can security deposit be paid to Section 8 voucher?
Yeah, you can charge a security deposit, so there's no prohibition against that, but now security deposits are changing as of July 1st of this year also.
Yeah.
So that
2
that
months,
also,
right?
pardon me?
It's 2 months.
It will be
Well,
changing
if
to
you're,
1 month.
if you're a
2 months.
small landlord, if you own a property or no more than 2 properties consisting of no more than 4 units, you can charge a 2-month security deposit, whether it's furnished or unfurnished. And 1 month's advance rent, nothing more than that. So the rule still applies in regards to 6 months or more advance rent if the lease is for 6 months or more. But, so that's something else that's gonna come into play for anybody that's renting units. If they have more than 4 total units, or more than 2 buildings with 4 units, 1 month security deposit and 1 month's advance rent, or 6 months or more if the lease is for 6 months or more. Furnished or not. I don't think we do too many leases with furnished properties. It seems to be rare in regards to what I'm saying. But what we actually encounter all the time are other agents who are not knowledgeable about this, and they're looking to get 2, 3, or 4, or 5 months rent in advance, or they want first and last month's rent. It's all illegal. And not only that, but now we'll get to that also, the penalties are severe. Before, the penalties associated with the Tenant Protection Act weren't that severe, but now it is. And this is an interesting one. SB 712 prohibits a landlord from prohibiting a tenant from owning personal micro mobility devices or from storing and recharging up to 1 personal micro mobility device in their dwelling unit for each person occupying the unit, subject to certain conditions and restrictions. So micro mobility devices, electric bikes, for example. That is a micro mobility device. So can you, as a landlord, prevent them from bringing that into the property? You cannot. And they're entitled to charge that in the property. Also, there can be something that's even gas operated, theoretically, that's falling under this category. Can you prevent them from bringing it into the property any longer? No, you cannot. So, and they can store it in the property. And then there are certain guidelines. I would have no idea about these standards in regards to must meet certain standards. And my guess is if it's an electric bike, it probably meets those standards, or you just have to be probably err in being conservative and say that they all do.
I'm not as concerned about that one. It used to be a problem when
Was
the
it?
hoverboards were catching on fire all the time.
Yeah,
Mhm.
I feel like it's like the older battery.
They used to charge them and just leave them in the house and then, go out for the day and they'd come back to the burnt down house. I don't think it's as big of a deal.
It's not anymore. Okay, so we're not seeing that as often.
After paying the electricity for that particular unit, now that's something you gotta take into account. This person's gonna charge their e-bike every day. That's
Yeah,
probably-
every day, right? And if there's multiple tenants in a property, right, and they all have bikes, so do people want that? I think most landlords don't want those vehicles in the property itself. I think that's probably the reason why. And then the question is, can a landlord prohibit a tenant from storing a bike on a balcony? Well, that's not addressed. So I don't know what the answer to that is.
How about the Airbnb? It doesn't apply to,
To an Airbnb,
uh-huh,
I would say that I don't know for sure because it's not mentioned necessarily in this Senate bill, but I would say it probably is no different.
For instance, when it comes to Airbnb, there are areas like a rent control,
Mhm.
like LA. Can somebody sit there, live there, because sometimes they are exchange students that they come and get a Airbnb
Mhm.
for other people and they be there for a while and then they don't pay.
And then they don't pay. So that goes back, I thought we were talking about the e-bikes or
Eviction.
micro mobility. Oh,
Yeah. Or just some areas that, like this, that it's not disclosed in the beginning, but later on, they,
I think I missed the question, so you're gonna have to forgive me. I'm gonna have to ask you to repeat the question.
when it comes to, there are certain rules that apply in general renting
Mhm.
the unit. But how about if it's an Airbnb? Because that's like a apply, it's
I understand
under
what you mean,
12
right.
months. So it's a different rule for it.
It could be,
Like
right?
when you are going to hotel,
Mhm.
maybe they.
Maybe
are-
there are rules and regulations that would prevent you from doing that.
Exactly.
I
That's
don't
what
know
I-
the answer to that is, but I think if I'm the person who's renting that unit out, maybe if I have rules and regulations that state you can't do it, is that a possibility? I don't know, because do I want, if I'm staying at the Four Seasons, do I want to see people bringing their e-bike up in the elevator? I
Yeah,
don't know.
that's what I am saying.
I'm not sure. I'm sure a tenant's gonna push it though. That's what I do feel confident about, right? Anyone that's staying in there for a couple of weeks. And your example is a perfect one. It's gonna be a student possibly that's going to use that. I don't know if a landlord can actually prevent that from taking place. That's a good question. And then crime-free rental housing programs and ordinances. Now, it's not that a landlord has invoked these guidelines, but there are areas in which it's deemed to be crime-free. So what is it? It's cooperation with the local police department, meaning ordinances would exist that would prevent, if somebody wants to participate in the program, it would prevent the landlord from having somebody that has a felony or engages with the police in a certain manner that's deemed to be negative. So if they were allowing to actually, it would allow a landlord to evict somebody based upon the fact that maybe 1 out of 7 family members is a convicted felon and they could evict them. So now the state of California is saying, well, there's no evidence that if we have criminals living among the community, that there's any additional crime because of that. So the ordinances are now deemed to be illegal, in which if you couldn't, and it doesn't give the landlord the ability any longer to evict somebody based upon the fact that they don't meet the guidelines of a crime-free zone. So around here, I'm not sure what that would exist, but it does in California.
Is that just like, after we check out their credit report, there's like a crime record?
Mhm.
We cannot say no because of that, like we say, reject their application because of that, right?
I would say this is more geared towards individuals that were already occupying the property and they were approved. But in your example, if it's somebody that is a convicted felon, you would actually have to make a determination. Well, how long ago did the infraction occur? Was it a year ago? Was it something that was a physical violation? That was a rape? Was it, what were the circumstances? If it occurred more than 10 years ago and it's a convicted felon, you deny them based upon that fact, you're going to be looking at problems. So last year, maybe, because it's recent, I would say you probably could find or actually use that as a reason for denying them access or credit and renting that unit.
So how far back can we go?
Well, that's a good question. I think 7 years is probably, anything beyond 7 years is probably no reason or valid reason for you to deny somebody credit. So I would look at 7 years. So the question becomes, do you want to look at their criminal background record? What do you do, Ryan?
Oh, wait, look.
Well, we don't deny based upon that, right?
Another opportunity to tell your clients about all the wonderful laws California has and why they need you and they can't just go out and do it themselves.
Yeah.
Because they're not keeping up with all these laws.
Yeah.
So would that any of these would be part of the crime report? Because I showed the house to a couple and the gentleman asked me that, what is the crime rate in this area?
I see.
So
This would be separate and distinct from that, but I think that the data is available for somebody to say what the crime rate is
Okay.
is
But
in that
is
area.
it our job to do this?
It is not.
It's not.
It is not.
And it's okay for me to say I'm not aware of that.
Yeah, I'm not aware of that. But if you can refer them, for example, to the information associated with Megan's Law, and they could see information associated with sex offenders.
Mhm.
If anybody's ever looked at that website, it's surprising that how many of your neighbors have been convicted of sex offenses. I'm sorry, what was that?
Better not look at that. Didn't-
You might want to live next to him. Who knows? It's a joke. Yeah, if you have young children, you have to question whether or not, but there's really nothing you can do. I don't know if any of your clients really look at Megan's website or Megan's Law website to see if there are sex offenders in the area.
None of my clients that I questioned that.
They do?
Oh,
Oh, they don't. They don't? Yeah. I don't think anybody really does. They don't think about it.
Yeah.
Just assume it's safe.
Like, oh, mine, it's safe, let's just go.
Yeah.
Because when you enter in the community, you can send it immediately. I think.
You can get a feel for community by driving through typically the appearance of the properties around it, the individuals. And you can see just people walking or elderly people walking around feeling safe, right? So it probably tells you that you're probably not at risk. Although we touch upon this, we'll just touch upon it again. So you cannot collect no more than 1 month's rent for either furnished or unfurnished units. Unless you're a small landlord, remember that's 2 months, 2 properties with no more than 4 units. Then you can collect 2 months security deposit and no more than 1 month's advance rent. Unless it's a service member, so that's another exception. And then, so we've talked, when anyone has a question about a lease and they want to discuss with me the ability to increase their rent or terminate a tenancy, what is always a question I ask about? Do you have the RCJC, the rent cap and just cause notification? And was the exemption box checked? So that prefaces what we're going to talk about here today. So remember, if the landlord is not exempt, they're subject to the Tenant Protection Act. And if they haven't taken actively the exemption, they're subject to the Tenant Protection Act. So keep that in mind. So now, yes.
Going back to the deposit, like if you represent the tenant and we deal with another agent and deposit is requested more than 1 month after July 1st, what do? We just go with it and assume that they check that landlord is a small landlord? Or do we ask them?
Oh, that's a good question. Yeah.
Well, you'll have it on the lease. The lease has, that you're reviewing and having your client sign, will have the RCJC box checked when it asks for the deposit amount. So you just skip ahead to the last page at least where the RCJC is and see if the box is checked.
Well, that I think the RCJC isn't addressing currently the question whether or not the landlord is a small landlord, right?
This is just for limited rent increase, but
Yeah, not necessarily the security deposit.
okay,
That
and okay. Turning back, if we represent the landlord, we ask them, you only have 1 or 2 units, then we can charge more than 1 month of security.
that's what you should be
deposit?
doing.
Okay.
You should be questioning them.
Uh-huh. Like, can we have that portion of the page, like, separated and,
Whatever you want.
yeah, so so we need to show it to the landlord to explain to them why they can or cannot do certain things.
I agree. I
I
think.
think 1 month's deposit, it's just not enough.
Mhm.
And I always recommend the landlord to charge months and a half deposit. Because even though you're not supposed to use deposit for the last month's rent, as we know, a lot of tenants do.
Mhm.
And if you only charge 1 month, you're often left with nothing. Can you charge cleaning fee up front? No.
A cleaning fee up front?
Yeah.
Well, I think you can actually state, we're going to clean the unit and it's your obligation to professionally clean the unit upon the expiration of your lease or before you move out. I think those are things that you can incorporate in the agreement.
Well, it's already there, but can we say, okay, you don't have to clean, we'll clean, and this is $500 upfront for you to move out?
I guess if they agree to it, what if they say they clean, then what?
Well, then they'll refund it.
Okay,
Yeah, as I understand it, they're entitled to remedy certain defects of the property. Like if they were to move out, and there's a hole in the wall, you know, that they put their fist through. You have to give them an opportunity to make the repair at their expense rather than charging them for that. So I would think cleaning is the same thing, as long as they do it to your standards. I think you probably.
Yeah, but
best err
with
on
1 month, I'm talking about in 6 months from now, when it's gonna be limited to 1 month. And the tenant would use that 1 month for the last month of rent. And the landlord end up with vacant property, tons of damages,
I
not clean, and not even half months. If it would be like months and a half in security deposit, at least half months would be left, and you can cover from that. But when it was just 1 month and tenant used it, landlord is left with nothing. So I'm trying to see what can be done to have somehow landlord covered for those expenses.
yeah. Well, I would say if you have in the lease agreement that if they don't clean it and it doesn't, and the cleanliness doesn't match the original conditions of the property, then you have the ability to charge them back.
Yeah, charge them, but where are you gonna go after them?
You're gonna
Like, you will have to go after them. You
Well,
will
that's-
have to-
We're not saying that this is advantageous to landlords.
No, I know, but I'm trying to figure it out.
What we can
help
do.
them.
Do you have a thought?
Well, yeah, I got a thought. It used to be when you were talking about security deposits, it'd be the maximum 2 months rent. The
Mhm.
landlords thought they would get clever by charging. Well, there's also a key deposit. There's also a pet deposit of another 500, trying to get it over that 2 months mark. And they came right in really quickly and said, no, it doesn't matter what you call the
Okay, 2
deposit. You
months,
can't
yeah,
collect
2
more than
months.
2
You
months.
can't even, we usually
got a
don't
feeling they're
charge
probably
2
gonna go down the
months.
same road
Months
with
and a
this
half
stuff.
is reasonable.
Yeah.
But again, they always use, not always, but very often use, I need to move, can I use a depository
Yeah.
my last month's rent? And if they're moving out, you really don't even worry about it, but only worry that there will be some money left to clean if they don't clean.
Mhm.
So in that regard, I never let them use their deposit for the
Well,
last.
how are
month.
you gonna not let them?
Because I'm gonna tell them I'm charging them legal fees if they don't have
Okay,
the rent. to-
charge them, go after them once they move out, you don't care, like, you're out, thank you, you're out. Thank you very much.
I don't think there's a simple solution in regards to what you're talking about. That's the real issue.
I know.
I wish there
Yeah,
were.
the state cares more about tenant.
Yes, tenant protection than it does the landlord who's at risk for the property.
Well, but we
They
worry
care
about
about tenants, they care about buyers, they don't care about sellers.
Care about tenants though. If I come across a good answer, I'm gonna give that to you. Unfortunately, I don't have a great answer for that one.
Two answers. I think that happened to me, at my rental property. So cause last month, they said, hey, I need to fix my car, I don't have money, I just use the security deposit as my last month's rent. Actually, as a landlord, if you ask only for 1 month deposit, it's really not that much you can do.
Nothing.
Like I do have two solutions. I think first one will be like a Brian said, when you can ask them something like a pet deposit or key deposit to cover it, but actually the cost won't be that much. If it's cost a lot, and then you can just go to the small court to a claim. But I think it's the maximum you can get the money from the tenants every year is maximum will be $10,000. That's how much money you can get next.
Yeah,
I think that's
again, this
you
is,
can do it.
this is time consuming, you don't know if you're gonna win, and
Welcome
you
to
need to deal
California.
with it.
Yeah,
Well, can you put on the contract at the beginning that you cannot use your last name?
it already says that. That's already, they just don't care.
I don't know, I have had people tell me that, and I tell them, well, listen, it's not gonna stop our procedure if your rent's not in by the 6th.
And that's gonna stop them if they're already asking.
no, I'm telling you.
Please God, they asking, because most of the time, if they wanna do that, they're just gonna inform you, oh, we're not gonna pay the last month, because otherwise we can't move. So, okay, just move, because you have like extra half month to cover.
Well,
But if
so
you
here's
don't-
how it works with most people. Like, if you did your screening up front, these people care about their credit, they care about judgments, they care about those sorts of things. If you're letting in people who don't care and we're just gonna like give you the middle finger on the way out, you're right, you're probably in trouble. But I
Well,
can tell you,
you're only talking about those right now, because good people, they're not gonna use
well,
their.
they try. I mean, but you tell them, hey, the process server to deliver the 3-day notice to you on the 6th is gonna cost $135. We're gonna hire the attorney. They're gonna start at 500, and if we stop immediately, that's where it'll end, but it could go up from there. And you know, before you get done with the list, they're thinking, ah, geez, this is more hassle than it's worth. And that's on top of the late fee that you feel like you're entitled to. That's $200. So before you're looking at it, it's like, all right, this is a $700 decision that I'm willing to send to my eviction attorney for collections, or you can just pay it. And 9 times out of 10, they just pay it. If you're already in like a confrontational relationship with a tenant, you're right. Sometimes they may just tell you no, and then you have a conversation with the owner. Hey, how hard do you want to push it? But I would say it works out more often than not, in my opinion.
Well, thank you. There you go. That's the best answer I've come across.
Yeah, always refer your tenant.
To Brian, exactly. That's
That's
exactly what you should be doing. Refer your tenants to Brian.
He's great.
But don't refer them once we're in litigation, right?
I like those.
Yeah, we don't want to take clients who are already suing, right?
But it's also a risk of being a landlord. That's the first
It is, it is. Shweta, you have a question or
So I
comment?
have enough for landlord and tenant about the fire hardening thing.
Uh-huh.
So now in the RPA, they have under disclosures that you can select a disclosure for the fire hardening, whatever.
Mhm.
Is it kind of necessary to choose that or? Can
To select the disclosure, well, it's based upon the circumstances, whether or not the FHCS is
on the,
required.
when you're putting in an offer, like say seller pays for termite report, buyer pays for home inspection. And then there's another box that pops up for, if you wanted, you know, fire disclosure
Mhm.
from certain authority. Is that, are we supposed to select it for each offer that we put in or?
Well, I think you possibly could,
Okay.
but do you know if it's in a high fire zone? At that point, you probably have no idea. You can only speculate
Yeah, so
until you get the NHD report. You could do it just, and then if it's not applicable, you could always say, if applicable, you could do something like that.
Then I looked at the map and see, are there any trees around? And then maybe I'm gonna put it in.
I don't think anybody knows. That's the problem with the NHD report currently. I think it was last revised in 1998. So now
After your offer is active.
you always get it after the fact. Exactly.
So now you're just submitting an offer, I'm like, should I be including this report or not? Because I want my offer to be accepted at this point.
Yeah, I would think if it's a seller's market, no, I would not even consider doing that. If it's a buyer's market, absolutely.
Yeah, I think right now it's back to seller's market.
Yeah.
We put in an offer and the lady goes, there are 13 offers on the house.
Yeah, so there's your answer. Don't put it in. Yeah, don't be a pain in the ass. Don't put it in. And then other things that have taken place, because remember, we talked about the RCJC. If you are not exempt or you haven't provided the exemption now, many landlords got clever. And so they would evict tenants based upon the fact that they intend to substantially remodel a property. I'm going to remodel it. You got to move out, right? It's too bad. Give you 1 month's relocation assistance. Well, now that has changed dramatically. So the law is much less favorable for landlords. So now these are the requirements when evicting somebody or terminating the tenancy based upon a substantial remodel. Owner must notify or identify in the written eviction notice the name or relationship to the owner. So I'm sorry. First of all, it could be a relationship or someone that's going to move in that's related to the owner. So I got ahead of myself here. So if you're going to evict somebody based upon the fact that you want a relative to move in, now the requirements are as follows. The owner must identify in a written eviction notice the name or relationship to the owner of the intended occupants and include notification that the tenant may request proof that the intended occupant is actually an owner or related to the owner. The owner or the family member must move within 90 days. And then the owner or their family member cannot be occupying a unit currently. Then if the intended occupant does not actually move in within 90 days or use the unit as their primary residence for at least a year, the owner must offer the unit back to the tenants who was evicted at the same rent and lease terms in effect at the time they were vacated
Wow.
and reimburse the tenant for reasonable moving expenses incurred. So if the former tenant does not move back in and the owner subsequently identifies a new tenant still within the year-long period after the eviction, they have to offer the unit available at the same rental rate they were charging the evicted tenant. So it's taking away incentive from a landlord to try and remove somebody, because even if I put it back in the market, my rental rate that I have to offer to not, so I'm in conformance to law, must be at the same rate I was charging the tenant that was evicted.
Who regulates that? I mean, unless
The
it's-
state attorney general is suing. That's who's doing it, the HCD, right?
How are they gonna find out unless the tenant finds out and goes after them and reports it, right?
Did you advertise it for rent anywhere? And was that rental rate different than
Yeah,
they saw?
I think that the real question is, when you have a landlord who thinks they're clever, this is the reason why they need you. Actually, what's interesting, when we have landlords that approach agents in our office, and now they're notified of what's required. Holden just had one, for example. He's had somebody that's been leasing a property since 2014. That landlord had no idea what he was doing in regards to renewing the lease with that existing tenant. So Holden got the listing for that, right? Yeah, because the landlord had no idea the obligations, no RCJC, anything like that. So they're just implications. So it's incumbent upon you to make them aware of the implications. Not only that, but the monetary fines now are really substantial. So that's the other thing that's in place that really wasn't there before. So now we can actually define just exactly what the cost would be for a landlord if they violate the laws. So then also in regards to remodeling, it must require the tenant to vacate for 30 days, meaning it's not habitable for at least 30 days. And then they must give written notice. And then the statement must include the following: if the substantial remodel of your unit or demolition of the property is described in this notice of termination is not commenced or completed, the owner must offer you the opportunity to re-rent your unit. I'm not going to read this whole thing, with a rental agreement containing the same terms. So tenants are becoming very clever. I think that's really what you should be relying on. And then also you have to get a description of the remodel, a copy of the permit or permits.
Wow.
Yeah.
How about if the owner passed away? And, the beneficiaries, they don't.
They're
want it.
subject to the same guidelines. There's no exemption. Let's see, and then we'll just, so it talks about damages. So there is injunctive relief, and so the damages, how would someone calculate damages? Well, there's a case that I'm not going to go through all the details, but the plaintiff said damages are equal to, I intended to live there for 5 to 10 years. This is also if you charge more rent than what's permitted by law. So remember, if you don't provide the exemption and you increase rent more than is permitted by law, that tenant can now sue, and now they can make a claim based upon what they believe the damage is to be. I'm going to live there for 10 years. So you're charging me $500 more per month than you're permitted by law. So $500, that's $6,000 a year, $60,000 at least. So that's how they would theoretically calculate damages. Now, the plaintiff and the defendant are going to have a different methodology for calculating damages. But then also, let's assume it's that, and I'm just lucky, but then also the damages are 3 times that amount plus punitive damages. So now it's a real penalty for a landlord that charges more than they should be charging. So they're going to calculate the actual damages, and then what the plaintiff is entitled to is 3 times that plus punitive damages. So if it's $60,000 times 3, $180,000 plus possibly punitive damages. So we want to be sure that the landlord provides notification they're exempt.
So how did you come up with 60,000?
If I said that I was paying $500 more per month, and I'm going to live, and I profess that I'm going to live there for 10 years.
Oh.
So that's $6,000
Oh, it
a year.
goes back.
Oh yeah, because I never intended to move. That's exactly what the plaintiff is going to say. I never intended to move. I like this place.
Wow.
Yeah, I'm going to live here 5 to 10 years at least. So you owe me based upon that. So $500 a month, $6,000 a year. I'm gonna live there for 10 years. That's $60,000, and triple damages, $180,000.
But the law is in effect now, not 10 years ago.
Correct. It's in effect now.
Yeah.
So
So
for the future.
for the future.
Yes,
Not
correct,
the past. They
correct,
don't-
correct. But each person obviously is gonna look at their damages differently. But that's probably not unrealistic in regards to the example I gave you.
I know of someone that because of the COVID, they, they reduced the owner reduced the rent amount for that individual
Mhm.
because of what the situation was. Can they go back to what they were paying before, or still have to?
It's
follow
based
the-
upon the lowest base rent during the last 12 months.
Wow.
So no, you cannot go back and saying you were paying $2,000 previously, I reduced your rent to $1,000. And now if I increase your rent, it's going to be based upon $1,000. That's the percentage. But if they're exempt, there is no cap. It's just taking advantage of the exemption. And that's what's so critical for landlords that have long-term leases with tenants. In most cases, the tenants were never served with the exemption notice.
Mhm.
So let's assume you have a landlord with a long-term lease and the rent cap and just cause notification was never provided.
So
And nor was-
long-term lease, it's a 1 year, but then.
But maybe
after
the
that,
tenant's been in there since
month to
2015.
month.
Yeah,
So
it could
it's
be,
still
right?
considered as a long-term.
There's a difference. It could be a month-to-month tenancy, or maybe they just continue through an addendum to extend the lease. So there's a big difference. If it's a month-to-month tenancy and the tenant doesn't, on their own agree to sign the rent cap and just cause notice, you can send it to them attached to a notice of change in terms of tenancy. And then within 30 days following delivery of that, the rent cap and just cause notice with the exemption becomes effective. And you can do the same thing with a rent increase. You can send them a notice of change in terms of tenancy, and that the effective rent increase will become effective 30 days thereafter. But if it's a lease that they continue to renew year after year, you can send them the RCJC. If they don't voluntarily sign it, then you're out of luck, because you can't change the terms of the lease on your unilaterally, can you? Just like I can't say, well, I've been leasing this property to you for $5,000 a month. And it's 6 months into our 1 year lease, I want to increase the rent to 10,000. Can you do that? No, you can't change the terms. That's why when you have landlords that have long-term tenants, it's critical that you intervene in the system in regards to what they're doing. And then there's going to be a prohibition against having exclusive listing agreements for more than 2 years, by the way. And apparently no longer can you record a long-term listing agreement, what I was not aware of. And that a new law prohibits. There were individuals that would go to elderly people and say, I want you to sign a 40-year listing agreement, exclusive listing agreement. And guess what? I'm going to give you $3,000. Oh, I need that. So no longer can you record a listing agreement against a property. And no longer can you have a leasing agreement for more than 2 years.
Shweta had one like that.
What?
Shweta had a transaction like that. Shweta, do you remember that one? Yeah, something. What did it have?
You, on your buyer's preliminary title report, remember there was that random listing agreement from like 3 or 4 years ago?
Yeah, it was a year ago.
Oh, was it a year
Yeah,
ago?
a
You
year
didn't
ago.
pay 'em
I
off?
remember that, right? It was you. I couldn't remember who it was of it.
Yeah. So it was some online,
Brokerage from
brokerage
out of
that
state.
had already had a listing agreement and the seller was not aware of it. And so it came up in the feelers that, while they were selling, so they had a big commission to the other listing agreement and this.
Yeah, actually, I think we even came across a one transaction, a grant deed that had a restriction in regards to a certain agent must list the property.
The finance is that,
A deed restriction, actually, yeah.
the finance is that listing
And was
agent
it
wasn't
valid?
even aware of it, that there was like that.
Yeah. But it's taking advantage. What a great idea. Go to somebody, spend $500 and say, sign a listing contract. You don't have to do anything. You're going to get money because you need money desperately. They're going to die. And then you've got a listing agreement. And it's a recorded notification. So everybody's aware of it. And it's enforceable. So now you can't do that anymore. For any of those of you that want to have a 40-year listing agreement.
Could have told us about this a couple years ago. Right?
I wish I thought about it, Brian. And then the other thing that's taking place, the state of California now is going to, or approving, remote online notaries. And I don't have a clear understanding of this, but it has to be implemented by January 1st of 2030. But also apparently the state of California will recognize a remote online notary, someone that's a notary out of state, in which the signer is signing, I think, in the state of California. Is that correct? That's the way I'm reading this, that the state of California will recognize that, but what about a title company or county?
So we are working through our provisions. The county is sounding like they're gonna be okay with it, but the title underwriters have a list of requirements. And I think right now we're standing at like 4 out of 5, but one of the big ones that X's a lot of people out is you must be a US citizen. So if I was in Shanghai and I wanted to use a remote notary, I could, but not someone who's not a US citizen. That's one of the big requirements that I think a lot of people aren't going to meet. And then tax returns, social security number, valid US ID. So you have to check off 4 out of these 5 boxes. And if you meet that criteria, they will do it.
The title company
The
will
title
accept it.
company.
Okay, will accept it and ensure the transaction.
I'm sorry?
That's just for the titles for the notaries?
That is for the notarized documents for whether they're loan documents or for the ownership vesting deed.
Okay, cause I took my notary earlier this year and they said that we could accept like foreigners. As long as they provided the correct documentation, but we would have to use our discretion, so that's why.
But that's not a remote online notarization.
Yeah,
That's in
for-
person.
Cause they were talking about for if like it goes into remote also, so that's why I was there.
But the difference is going to be at most title companies, they have an approved list of notaries. If you're not on that list, they're not going to accept your
That's one of the
notarization
two,
anyways. Yeah.
So if you're accepting an offer from like, from an overseas citizen, whatever, and they say they have funds, but they're gonna be traveling and they don't have a US ID, whatever, it could delay the closing unless they're planning on coming back.
But we're talking about a buyer,
Yeah, buyer.
but it wouldn't matter. There's nothing that they have to
Unless they're getting a
notarize unless they're getting a loan.
Yeah, because a lot of people, it would consider an investment property if they're getting a loan on home if they are not US residents.
Yeah, I don't think it has anything to do with title and them providing a title policy because the buyer is not a US citizen. Yeah. It wouldn't matter. It's only if it's the seller.
Seller, yes.
Yeah.
So it'll be interesting to see how it unravels. I know a lot of people are excited and it does create some opportunities, but it also creates some risks.
Yeah. And then we'll quickly finish this. Small claims.
A question before.
Oh, I'm sorry.
RCJC, Shirley's asking, what if the tenant refuses to sign the RCJC from the beginning of the renewal?
Well, if you attach the RCJC to the lease and they refuse to sign it, then you don't have to renew. That's the term under which the landlord is offering the renewal. If it's a month-to-month tenancy and they refuse to sign, then you can send it attached to a notice of change in terms of tenancy. And even if they don't sign 30 days after delivery, it becomes effective.
Isn't notification just required, not necessarily their agreement to it? I mean, don't you just?
Well, that's just it. But to change the terms of any tenancy, a month-to-month tenancy, you have to serve them written notification. It doesn't become effective until 30 days after they've been served with that change of the terms of tenancy. And the RCJC is the analogy that I can best use is an increase in rent. Small claims actions going up to 12,500 for natural persons. And what is it? 6,250 for anything other than a natural person. And then vacation rentals, not that I have much information on it, but apparently anyone offering a property for vacation rental must disclose all the additional fees, cleaning, so on and so forth, although what is not required are governmental fees that must be disclosed. And there are different guidelines in regards to termination if you have for vacation rental, if you've made a reservation more than 72 hours in advance and you notify them, you're entitled to a full refund. But we don't do vacation rentals anyways.
Mhm.
But, so that's the end of my discussion today. Sally's happy. Well, can't believe it's over. Yeah, Julia?
Any update on the commission paid by the buyer to? the
Oh,
seller?
no, in regards to litigation, not that I'm aware of. No, nothing has changed at this point in time. So there's no obligation to have a buyer representation agreement, if that's what you're wondering at this point in time. Nothing has changed, but I think at some point in time, we can count on that changing.
Mhm.
And when it does, everybody's going to be obligated to use a buyer representation agreement. So whenever that occurs, I think it's gonna drag out for a while. Yeah. But there have been apparently other law offices, real estate offices that have been sued, but that's not a real surprise. Well, hey, it's good to see everybody. Thank you for coming today. And next week, we'll have somebody here to address the NHD report. And so we can address the high fire severity zones, all the severity zones. Also, I would say the disclosure associated with that. So it is very important. So we have a complete understanding of that.
It's at a different time next week, right?
10:30, I'm sorry, it is at 10:30. So it's gonna go from 10:30 to 11:30, and then lunch will be served after that. But you have to be here at 10:30 to eat lunch at 11:30.
Yeah.
Thanks for coming, everybody.
All right.